Alderman Devaney. Alderman Guy.
Here. Alderman Devaney is here.
Thank you. Alderman Guy.
Here.
Alderman Kerrigan.
Alderman Kerrigan will be a wee bit late. He'll be signing in later on.
Councillor Sonoya Barr. Councillor Bowen. Councillor Carr. Councillor Duffy.
Shaw.
Councillor Edwards.
And Shaw, Karen.
Councillor Farrell.
Here.
Councillor Ferguson.
Here online, Karen.
Councillor Fleming. Councillor Harkin.
Here.
Councillor McGinley.
And Shaw online, Karen.
Thank you. And Councillor Tierney.
Here, Karen.
And can I just do a double check on Councillor Sonoya Barr? Okay, thank you.
Thanking you, Karen, and you're all very welcome, members. If I could read the broadcasting statement, please. I would like to remind everyone present at this meeting in the Guildhall or in attendance remotely that this meeting will be broadcast live to the internet and will be capable of repeated viewing. This broadcast may be terminated or suspended in accordance with our protocol. Due to your attendance at this meeting, you are consenting to being filmed and to the use and storage of those images for broadcasting or training purposes and for the purpose of keeping historical records and making those records available to the public. Members and approved speakers are reminded to only have their mics and cameras on while speaking at the meeting and to use the chat facility to highlight a request to speak. A copy of the council privacy notice may be found on the council website. Members, moving on to declaration of members' interests, and if I could start by declaring an interest in items 14 and 18 as a member of the PCSP. 14 and 18.
And Chair Alderman Devaney here, could I just declare an interest in the PCSP as well, Chair?
14 and 18, Morris?
Yep.
Okay, thank you. Councillor Dovey?
Yeah, Chair, 14 and 18 as well for myself as a member of the PCSP.
Chair,
Okay.
14 and 18 too, as well for me. PCSP.
Okay, Alderman Guy, Darren, thanks. Councillor Michaela Boyle?
14 and 18 as a member of PCSP, and also item 10, the sports grant, a member of Sigerson's GA Club.
Okay, folks, moving on to chairperson's business, and just to say I have two councillors who have asked to avail of chairperson's business. And first, if I could call upon Councillor Sean Harkin. Sean.
Thank you, Chair, for letting me in, and I appreciate it. I wanted to raise the publication of the Coronavirus Lessons to be Learned to Date report that came out from Westminster over the last week. And I'm sure everybody was as shocked as me about the findings that found serious negligence on the part of the government in terms of its initial response to the pandemic that led to many thousands of people dying unnecessarily because of the government's main strategy at the time, which was herd immunity, which had never been trialed before in the face of a major disease anywhere in the world. And I think it spoke to the utter arrogance of the Tories that they thought keeping open the economy was far more important than listening to expert health advice. And so they ignored policies such as mass testing, banning large gatherings, face coverings, screening people coming into airports, cancelling non-essential travel. All that was ignored, and what we got was the health minister at the time telling people to wash their hands and sing happy birthday. It was another disgrace, and I'm glad that there is a report now that can begin to hold people accountable. The report obviously is to do with England, but our issue is that for a period, the Stormont executive replicated the Westminster approach, and many people here died as a result, because what was done in Westminster was repeated in Stormont. Things like moving people out of hospitals into social care, into care homes, was a disaster and led to unnecessary deaths. And there are many people now who lost a loved one, who suffered, illness because of COVID, because of these disastrous policies that came both from Westminster and from Stormont. And I think that we have to do the same here. We have to have reports that document the executive's handling of the pandemic. And I believe we also have to have a public inquiry into it within the time frame of the existing government. So I want to ask committee to support a proposal that we write to the executive, and if they are not doing it already, that they action a report, probably to be done by the health committee, on the executive's handling of the pandemic, and that we also ask the executive, write to the executive to ask the executive to urge the executive to hold a public inquiry into its own handling of the pandemic within the time frame of this government. And I think that this is very important, because for many people, people lost their lives, and this is just on the health response. The whole issue of how money was handled and how it was distributed will be a separate report and investigation. But I think that given the scale of this pandemic, how much it impacted society, that we can't just act as if it never happened. There has to be an accounting in terms of how Stormont handled it. And then people have to be held accountable for decisions that led to unnecessary deaths. So I hope the committee will support these proposals. We're really just writing letters to the executive, asking it to action a report and hold an inquiry, which should be straightforward. And if this place is in any way democratic, this is what we should expect. Thank you, Chair.
Thank you, Sean. And folks, could I just acknowledge from Councillor Edwards declaring an interest in item 10. Folks, obviously Councillor Harkin has spoke to and put into the chat box. Now, as people in the chamber able to see what it is? Everybody okay? Rory? Okay. Okay, folks, I have a proposer. Is there a seconder?
Chair, Councillor Carr here, happy to second that.
Councillor Carr, Sean, second.
Vice Chair.
Okay, I'll give people a minute or two to read. Okay, folks, there's a proposal which is proposed and seconded. Anybody looking to speak to it? I don't see anybody in terms of on the wires so far in the chat box. Councillor Duffy, Sandra.
Thank you, Chair, for allowing me in to speak on this really important issue, and to thank Councillor Harkin for raising the issue, because it is a really important issue that we should be discussing and should be just talking about. I can hear myself, sorry, through my iPad. But absolutely, there's no denying at all that there has been lives lost in relation to how the Tory government and indeed the British government handled the outset of COVID. Their failure to listen to health advice, their unwillingness to take on board the expert opinions, the warnings that were there. It was just ignorance on their part, or complete negligence, as Councillor Harkin has alluded to. In terms of the proposal, I know in terms of, if you think back to the time, Sinn Féin were to the fore of calling for an all-Ireland approach. We were looking to follow WHO advice in terms of test. We were looking to ensure that the schools were closed at a very early stage and to lock down to protect our citizens. Unfortunately, that didn't happen, and there probably is questions to be asked around what was the blockage in terms of getting those actions and following up on them. I don't know at this point if if it's even possible to hold a public inquiry within the mandate of this executive. Time is running out, as we all know. There's lots of business that the executive does have to get through. There are certainly questions to be asked. I would be happy to write a letter to the executive and ask for a report, but I don't feel at this point that it's even possible to have a public inquiry before the expected date of an election, which would be May, whether there's one before that or not. But I do welcome the opportunity to have a discussion on this issue. It is a really important issue, and we do know that there were extreme failures at the outset of COVID. Thank you.
Thank you, Councillor Duffy. Alderman Guy, Darn.
You, Chair, for letting me in. I would agree with the first half of. I would agree with the previous speaker. What she said, there definitely has needs to be a full report by not just the government, but obviously our own government as well. I would question the second part of it, asking for a public inquiry, and I would agree again with the previous speaker and what she says, that there's obviously a lot of work to get through. I think maybe let's wait and see what actually comes out from the response first before we call for any public inquiries and just backlog the system. Thanks, Chair.
Thank you, Darn. Alderman Devaney, Morris.
Thank you, Chair, for allowing me in. And look, as the previous speaker, I do fully support the first part of the recommendation to write to the Stormont executive and regarding the issue and the failings that took place. I also believe that, look, a public inquiry with the mandate that's about to come to an end very shortly, maybe quicker than we think, but hopefully May next year. You know, at the end of the day, I don't think there's time for that. Like the previous speaker, look, I support the gist of it. We support the gist of it, but just the concern around the public inquiry, that, look, it'll probably fall between the two stools. So it will. Thank you, Chair.
Thank you, Morris. Councillor Ferguson, Rachel.
Thank you, Chair. Absolutely. I think what we've seen this week has definitely highlighted that there has been failings in response to the COVID pandemic. And, you know, it's also highlighting things that have worked well. And, you know, we are best whenever we know all the information and when we review it and we find out where we went wrong and where we did well. I know our city and district locked down a lot sooner than others and got a lot of flack for it, but actually in the first lockdown it worked out well for us. Unfortunately it didn't, you know, we still had further lockdowns after that resulted in losing quite a few citizens, unfortunately. but I'm happy to support the motion. I agree with the sentiments of the previous speakers. I think we can request a public inquiry. I think to put a time limit on it where it's an existing mandate may just mean that they won't take it as seriously as it should be taken. I think if we were just to request a public inquiry, because everybody needs to know what went well and what went wrong, and that's the best way to go forward. But I'm happy to support it, even though I don't think that it will be able to be done within this current mandate.
Thanking you, Rachel. Of two further speakers, Councillor Tierney, Brian.
Thank you, Chair. And like everyone else, I think this is a very important issue, and it's one that we have to understand first and foremost what is currently, if anything, is going on within the executive and within the health committee. To maybe prepare this report. For all we know, that report could be being worked on as we speak, which would negate the first part of this proposal. It's clear, and anybody who's been watching or listening to the news over recent days, that there was failings, and the report that came out from the Westminster Select Committee has very, very clearly identified where those failings were, and it's completely unfortunate that those failings in many instances led to the loss of life. We, like others at that particular time, were calling for an all-island approach and calling for the executive to work hand in hand with the Irish government right across the island. I know I and many of my colleagues were contacted from the very outset of the pandemic by cross-border workers who literally didn't know whether they were coming or going in terms of restrictions. And it was a very, very difficult time for them. That was one of the reasons why we were looking at that we would address the pandemic in an all-island basis to try and protect people. We would be supportive of a report from the Health Committee in Stormont, because I think we will find that there are lessons that could be learned, but we also have to recognise and understand that whilst they were dealing with this, they were dealing in a crisis and an emergency situation. But where lessons should be learned, can be learned, they should be learned. I would agree with others as well in terms of putting a time frame on any public inquiry by the end of the existing mandate at Stormont. Everybody knows, what's been talked about at the moment. I think Alderman Devaney alluded to it. Maybe he knows something that the rest of us don't at the minute. But you're talking realistically 7 months to set up, hold, and adjudicate on a public inquiry. I don't think it's possible to do that. So I think we really need to understand of the ask that we're asking, and we're setting ourselves up for something that ain't going to happen, because it's not possible within the time frame. I would like to see a report from the Health Committee at Stormont to find out where those failings were, and then at that point, I think we are then able to take it forward and decide whether we do or we don't need a public inquiry at that point. Thank you.
Thank you, Brian. Alderman Carr, Sean.
No, still a councillor, Chair. Thanks, Paul. I'm happy to second this proposal by Councillor Harkin. And I think that we write this letter in its entirety, what was proposed, and wait for the executive to respond to it. No, it's not for us as councillors sitting here in Derry to respond to this. It's for the executive to respond. And I think we should write the letter and wait for the response. Thanks, Chair.
Thanking you, Sean. Councillor Harkin.
Thank you again, Chair, and thank you, Councillor Carr, for seconding the proposal. Look, I appreciate people's points, and yeah, the Tories led the way in this, and I would call the herd immunity social murder, in that they created conditions where thousands of people died unnecessarily. And I also think that Stormont, for a period, followed along with the strategy of the Tories until there was uproar from many people here that it was a disaster. So you know, the issue is we shouldn't need to be calling on the Stormont executive to have a report done. It should be already set. It should be ready to come out now. And they should already be talking about a public inquiry because people need to be held to account. I mean, there are all sorts of issues here. Look, there's an election coming up, and people should be held to account in terms of how they handle the pandemic. It sounds to me like all the executive parties are saying this can wait until after an election, and let the executive respond, because the pandemic has been an unprecedented issue for all of us to deal with in society. And if there were massive mistakes made that led to people dying in care homes unnecessarily, the people that made those decisions should be held to account. And that's what a report can do, begin the process of, but it's also what a public inquiry can do. So the executive, if it decided, can organise a public inquiry very quickly. And I may not be confident that they would do it, because I think that, you know, I look at the RHI inquiry and find out there's nothing here to see. But I think that our council should be putting a demand on behalf of those people who died, or the people who lost their lives, and the families who are dealing with bereavement, on behalf of those healthcare workers who were faced with an unprecedented situation that has caused immense strain, demoralisation to them, but also to our health service. That's who our council's putting this request forward on behalf of. So yeah, I would like to keep the original proposal that we asked the executive for, both a report and I would like to see the response to the request for a public inquiry. Thank you, Chair.
Folks have two further speakers, and I know it is an important issue, so I'm going to, in terms of people who are speaking for the second time, but Councillor Duffy, Sandra.
Thank you, Chair. And I actually, I'm going to propose an amendment, so that's why I've asked to speak again. In terms of Councillor Harkin talking about the executive parties and the fact that there's an election coming up, just as a sideline, I look forward to people before profit announcing their candidate. We'll see then. In terms of the proposal that's on the floor, I think that there is nearly a consensus on here that we're content with the first part of the proposal. The second part, it's not any type of defence mechanism by executive parties. It's stating the reality of a situation in terms of timeframes and public inquiries. So I would propose that we remove that second part of the proposal and go with the first part in terms of the report. That's my proposal, Chair. Thank you.
I'm sorry, of Councillor Tierney, but just before I bring Brian in, could you just clarify to be clear what it is?
Yeah. When you get to response to the COVID pandemic, full stop, just end it there.
So just to say, folks, there's an amendment. If people are clear on what the amendment is, it's to take out, in a sense, the second paragraph. Council will write to the Stormont Executive requesting a public inquiry on its response to the pandemic be held within its existing mandate. That's the proposed amendment. I'll now bring in Councillor Tierney. Brian.
Chair, thank you for allowing me back on. I just want to respond to some of the remarks that were made in relation to trying to hide from a public inquiry or anything like that. This is a really, really important issue, and I think it's really, really important that if there is to be a public inquiry, that it's done right and it's done in the right time frame. Asking the executive, best case scenario, if the executive were to get this letter after full council and decide that because Derry City and Strabane District Council want a public inquiry held before the end of this mandate, and they would stop everything that they were doing and have this mandate, have this public inquiry, in my opinion, it wouldn't be done right because it would be rushed. It is a very, very important piece of work that needs to be done, and it needs to be done right. So putting a time frame on it to try and get it done so people may or may not be able to use it in an election campaign is completely and utterly irresponsible, in my opinion. And for that reason, we will be happy to support the amendment from Councillor Duffy. It's not that we're against, and I want to be very, very clear on this, it's not that we're against a public inquiry. We want the public inquiry if one is needed, but we want it to be done right and done and allowed, pardon me, allowed the right time and space to gather up all of the lots and lots of different accounts of how the executive handled the pandemic, given time to do that, to study it, to understand it, and then to adjudicate on it. I think that's going to take a lot longer than 7 months, and for that reason, we're going to support the amendment from Councillor Duffy. Thank you.
Thank you, Brian. Folks, I'm just conscious, or sorry, I wasn't conscious. Karen's just said to me about we need a seconder for the amendment.
And second that.
Seconded by Councillor Michaela Boyle. Alderman Devaney, Morris.
Thank you, Chair. Just on the amendment, our party would be very supportive of the amendment here. And like previous speakers, I do believe that a rushed public inquiry won't get the right results, as previous speakers have said. And, you know, we have to give it justice, give it time to, as the previous speaker said, time to get all the facts together and get the right argument and the timing right for a public inquiry. And, you know, this is an issue that people should not be politicking on. I think, as we said, people have lost their lives here, and for to get the right result for those loved ones who lost family during the COVID, I think it's right that we as a council get it right and get the timing right. And look, as I said before, I don't think it's a time for politicking. Thank you, Chair.
Thanking you, Morris. Alderman Guy, Darren.
Chair, and just concurring with everyone else, I do support the amendment. I do believe that, you know, when it comes around and when it has time, that if a public inquiry is needed, then we should bring one, and we should bring transparency to everything that has gone on during the pandemic. And people need transparency in it, so I'm happy to support the amendment.
Thanking you, Darren. And I don't see any further speakers, members, so I'm going to move to a vote on the amendment and ask Karen to take that.
Okay, members, can I have your vote firstly? Alderman Devaney,
For the amendment.
Alderman Guy,
Or
Alderman Kerrigan, Councillor Sonoya Barr, Councillor Boyd,
Or
Councillor Carr,
Abstain.
Councillor Duffy,
or
Councillor Edwards, Councillor Edwards, Councillor Farrell,
Or
Councillor Ferguson,
Or Karen.
Councillor Fleming,
Or Karen.
Councillor Harkin,
Against.
Councillor McGinley,
for Karen.
and Councillor Tierney.
Or
Thank you.
Karen, I see in the chat box, Councillor Stephen Edwards for Karen. So the amendments carried. And back to the substantive motion. Councillor Harkin, do you want to sum up?
Chair, can I propose a further amendment?
I'll come back to you, Councillor Harkin.
That's fine.
Brian.
Thank you, Chair, for allowing me in. As I've said already, I think this is a very, very important issue, and I don't want, and it shouldn't be used by anyone for politicking, especially in the run-up to an election. I think if there are lessons to be learned, and if a public inquiry is needed in due course, then this council should be calling for one. My main reason around supporting the amendment was because it took out the time frame that held it up. So I would like to propose that where it ends there at pandemic, that council will support a properly consulted public inquiry if required in due course.
May you just give it a try? I know. Councillor Tierney, Brian's just putting this in writing, folks.
I'll second that.
Seconded by Councillor Farrell, Rory. Brian's doing that. I've an indicated speaker and Councillor Duffy, Sandra.
Yeah, just to say from the former words that appeared, don't have an issue with the further amendment.
Thank you, Sandra.
And Chair Alderman Devaney here, just to speed up the words that I've heard as well. We would be happy to support it as well.
Thank you, Morris.
Should be in the chat box, Chair.
Folks, that's amendment from Councillor Tierney. Brian's in the chat box. This council will support a properly constituted public inquiry if required in due course. And Councillor Ferguson, Rachel, has given her support to it, as well as those that have spoken so far.
Chair Darren here, I'd be happy enough with that too.
Thank you, Darren. Folks, we don't hear anybody
Chair,
speak.
Councillor Kerr, happy to support as well.
Sean? Okay, folks, I don't hear anybody speaking against the amendment that's put forward by Councillor Tierney, Brian. So unless anybody does or puts it in the chat box, only take the amendment as supported unanimously. And therefore move to the substantive motion. Amendments passed, sorry, and move to the substantive motion and asked Councillor Harkin. Sean, do you want to sum up?
Thank you, Chair. Yeah, I know people say that there should be no politicking around the issue of the pandemic, but the pandemic is politics, and that's why there's been a report done by Westminster. So I say again, why isn't there already a report coming out by the executive? Why are we writing this letter? It's because there isn't any forward movement, from what I can see, by any of the executive parties to actually put out a report describing what's been done during the pandemic. And everybody wants to claim that they did their best, but serious mistakes were made, and that people should be held to account. There's lots of people who died, unfortunately, that should never have died because of disastrous mistakes that were made. Replicating what the Tories did here, with even though there were appeals to change course, to do things differently, and our government should be held to account. And it's disappointing today that people talk about holding government to account as politicking. It's the opposite of politicking. It's actually saying we need transparency. And unfortunately, there's a long, long legacy of a lack of transparency coming from the new Stormont executive. Harken back to the old ways things were done. But hopefully, look, the message is still clear coming from our council that there needs to be a report actioned. An inquiry should be held, and I've no doubt if there is a report done, it will make clear why there needs to be an inquiry, because many people, thousands of people, healthcare workers, have questions about the chaos that they were thrown into in many situations unnecessarily, and I think people have the right to hold government accountable for the way in which this pandemic has been handled. Thank you, Chair.
Thank you, Councillor Harkin.
Chair, excuse me. Apologies. Just before you move to a vote, I've noticed a wee spelling mistake on that, if it can be corrected. Just it says council will support a property constituted inquiry. If that could be changed to properly, and it's my own mistake, so apologies.
Just to say, folks, we're joined by Councillor Valence, Bar. Just joined the meeting. Thank you, Valence. Okay, folks, moving on to the substantive motion, and can I take it that it's unanimous, folks, given the two amendments? And now we have a motion that is unanimous to us all. Okay, thanking you. In terms of the second item of chairperson's business, could I ask Councillor Emma McGinley, please?
Very good, Chair, for letting me in to raise this issue. Over the past week, I've been contacted by multiple teams who play in the Saturday and Sunday morning leagues and others who are paying to use council pitches, including the Brandywell, but they're being told that they aren't allowed to use the changing facilities of the showers. I can understand that we're still coming out of a pandemic and, risk assessments are needed and all that, but teams such as Derry City Institute and the Science Fest ladies are being permitted access to changing facilities. And when I've raised this with council officers, I was told that it's because they're deemed to be elite teams. Now, it's my understanding that the executive guidelines around COVID have dropped that distinction that allows elite teams to have additional access to facilities. At the minute, we have a situation where players in these leagues are having to change in their cars or in the stands at pitches. There's teams that are coming in from other areas having to change in the stands, and to be honest, I just think it's entirely unfair because these teams are actually paying for the facilities and should have access to be able to get changed before or after their matches, especially whenever we're moving now into colder and wetter weather. The executive guidelines state that changing rooms and shower facilities can be opened but should minimise use where possible. It's my understanding that all areas, including facilities in Limavady, have their changing and shower facilities open. So I'm sort of struggling to understand the reasoning as to why we're denying teams who are paying for the use of our council facilities, which includes the changing rooms and showers. Why are they being denied access? I'm just hoping that we can get an update here today and have it looked at as a matter of urgency so that these rate-paying constituents can get access to the services that they're paying for. Very good.
Thanking you, Emma. Any further speakers on this? Councillor Tierney, Brian.
Chair, thanks, and thanks to Councillor McGinley for raising this issue. I had planned to raise it under the minutes of last month's meeting. I fully agree with Councillor McGinley. Whether you're an elite sports person or not, you can still carry COVID and you still have the same risk. So I think it's only right and fair that all teams that are using our facilities are able to avail of the same opportunity of using all of the facilities. So we would be quite happy to support Councillor McGinley and what she's saying. Thank you.
Thanking you, Councillor Tierney. Thanking you, Brian. Councillor Harkin, Sean.
Thank you, Chair, and thank you, Councillor McGinley, for raising this. And I'm sure the football teams that have been in touch with you and in touch with me and in touch with others will be thankful that it's being discussed here today. And yeah, it's a very frustrating situation for them. I think for when it was warm coming out of the summer, it wasn't so bad to be changing at the side of the pitch. Now it's wet. Pitches are waterlogged already, waterlogged. And it's got very frustrating for them, and I think it'll lead to players not wanting to play because it's just ridiculous that you have people changing on the side of the pitch, not having access to amenities, whether it's a bathroom or a shower. And I think that they've been very, very patient about this, and they've tried to go through the council with requests, and they've contacted councillors, obviously. And I know that there has been I appreciated that Barry earlier wrote up Barry O'Hagan wrote up a very detailed response about why it couldn't be actioned on immediately. But I think we have to have a look at it. I mean, I suggested to that one solution might have been even to have all the teams be issued with lateral flow tests where they could do it themselves, and anybody that turned up positive wouldn't be able to use a changing room. And I think that would be in the interest of the team, obviously. And I think that the teams would take that task very seriously. That's only one proposal. The other one is obviously to look at people just being able to access the changing rooms. And I agree, look, if elite teams are getting to use changing rooms, what's the difference with local footballers and others getting to use changing rooms? There's nobody going into changing rooms with a COVID passport. So I think that this is something that we need to look at quickly as it gets colder. Thank you, Chair.
Again, you, Councillor Harkin. Councillor Boyle, Michaela.
Yeah, thank you, Chair, and thank you to Councillor Yanley for raising this today. I did raise it before a while back, and I do appreciate at that time there was a risk assessment to be carried out on that, and I do understand and the fact that it does take a lot of council resource in terms of a risk. Well, if a risk assessment was carried out, and you would have to clean and deep clean, and all of that comes with the risk assessment. But just in terms of the facilities and not being able to access changing rooms, I'm looking clarity. Obviously, the bathrooms would be included in that. So just I want to know, are teams able to access bathroom facilities, as in i.e. the toilets? Is that still a no? Or because I know we did have a complaint a way back in terms of Melvin about people urinating on the pitches and along the sidelines and that, who weren't being able to use the bathroom. So I just want to know, is that still the case, basically? Thanks.
Thank you, Michaela. May I ask Karen?
Chair, members, just in terms of the use of pitches, you very rightly referred to executive guidance. We also liaise with governing bodies, and to date the message has been one of caution in as much as possible, but that's the approach that our staff have taken. I do know at the start of the month the head of service did a review in conjunction with our corporate health and safety team, particularly around the implications arising from social distancing, from safeguarding issues in terms of our staff, around the compliance and the measures needed to be put in place by teams, should there be relaxations in terms of the use of changing rooms. And my last update in that matter, and I'm happy to come back to you with a further and more detailed report and to have a communication drafted for clubs, is that taking into account those issues and the social distancing implications, and any decision to fully open those changing rooms, then we would be doing that on a risk assessed basis. Now, not all of our changing rooms, some are in small rural facilities, are quite small. Obviously then we have much more substantive facilities in places like our Brandywell. So the numbers and utilisation of those may vary site by site. So there's not just a generic answer in terms of that. In terms of bathroom facilities, yes, there should be access on a as needed basis to those going forward. And if there's any specific issues, members, I'm happy to come back and look at individual sites or speak with individual teams. Thank you.
Karen, just given the nature and the sort of the immediacy of the situation, could a report come back to full council?
Yes, members, and if there's issues that we can resolve in advance of that, in collaboration with governing bodies and clubs, we're happy to take that up as well and formalise the position for the full council.
Okay,
Chair Morris here. I was looking to come in just before Karen spoke, and maybe you just missed me.
That Morris, my apologies. Alderman Devaney, Morris.
No, thank you, Chair. And I know it can happen very handy. You can miss names sometimes. But look, I want to support the rest of the speakers. It has been a concern that has been raised with myself from about changing facilities all over the council area. And I know I had spoken to someone, I can't remember who it was, and they said, look, that there was a possibility maybe that the larger change of facilities would be able to be facilitated maybe after the risk assessment was done. But the smaller ones, the prefab, the porta cabins that a lot of rural clubs have, wouldn't be able to open because they didn't have the room in them. Social distance, and I take on board the comments by Karen as well. But we have a situation where we're being criticised because, as previous speakers have said, elite teams can use the changing facilities. And I think it's something that we need to look at and address. And I also believe, Chair, that look, in the meantime, that any place that has even at least, if we could open the toilets to oversee the report coming back where toilets can be open, that they are open, and that mitigates the issue and around adults or whatever it is urinating along the edge of the pitch where we have children playing and stuff like that there. And it does happen sometimes that people take short and can't get to a toilet. But Chair, very supportive of the rest of the speakers. Thank you, Chair.
Thank you, Alderman Devaney. Councillor Tierney, Brian.
Chair, thank you, and thanks to Karen for the response. In relation to the response, and you'll appreciate, Karen, that I was trying to jot that down as you were talking. You mentioned that the head of service, along with the council corporate health and safety officer, had a meeting to discuss this, and some of the concerns that I have jotted down were safeguarding social distancing and safeguarding for staff. There was others then as well, but even just those three issues, why would they be any different for elite and non-elite footballers? If Derry City Institute or anybody else can change in the Brandywell, then why can Brandywell Harps, Poplar Hill Celtic, or any other Saturday morning club who may not be classed as an elite club? Because that's the part of this I think that the public are struggling to understand, and I'm certainly struggling to understand it as well.
Chair, I can't be definitive on behalf of all clubs, but obviously in terms of elite, there are different operational procedures in place, including testing arrangements for players. And obviously the situation in terms of COVID has moved on, but there were significant and stringent measures proposed by the governing bodies for those section of clubs. Now, obviously, what other, I suppose, grassroots football teams do varies because they don't come with the same resources or the same necessary structures in terms of having capacity to, for example, implement lateral flow testing, etc. But we're very open to keeping it under review. And to say I'll report back to you and give you a confirmed position at full council.
Okay, thank you, Karen. Okay, thank you, members. Moving on, and members, with your permission, if we could bring item 7 ahead of item 6, ahead of the minutes of the last meeting. People content enough with that? Okay, I'm going to ask Seamus to give us an update to this. Item was obviously before us at our last meeting, and it was deferred, so it's back with us. And just on your behalf, to welcome again the legal representatives, Kieran Hampson and Alan Stewart, and Seamus, our officer, to give an update.
Thank you, Chair. Members, following the hearing held by this committee on the 16th of September, council officers were requested to provide additional information to help members determine the application for the grant of an amusement permit for premises located at 15 William Street. In terms of the suitability of the location, although the previous report had outlined that no schools, youth centres or residential institutions for vulnerable people were known to be within 200 metres of the premises, officers have reviewed the proximity of Pilots Row, Community Centre and In Your Space, and the report outlines the distances between these buildings and 15 William Street depending on the walking route taken. Members, by way of a recap, Council adopted an amusement permit policy in 2019, which serves as a guide for assessing applications for amusement permits. Where the application is not a renewal of an existing permit or part of a major development, and it's on a ground floor development, there has been an amusement arcade operating at these premises since 2005. Following the public advertisement, 2 objections were received on the grounds that there were sufficient amusement arcades in the city and district already. The members, you'll be aware that there's currently 9 amusement arcades in the city. Chair, members are reminded that Council may depart from the policy where appropriate and rationale for any deviation is outlined. And if committee refuses to grant the application or grants the application subject to discretionary conditions, the applicant may appeal within 21 days to the county court. Chair, the applicant's legal representatives are present at this meeting in order to make a case as to why the permit should be granted. And chairs recommend that members take account of the updated information contained in the report when determining this application.
Thank you, Seamus. And if I could invite the legal representative, Alan Stewart. Alan?
Thank you very much, Chair. Can you hear me okay and see me okay?
Sorry, Alan, I didn't catch what you said.
I was just asking if you could, if you could hear me okay and see me okay.
Yes, we can. Alan.
Okay, there might be a little bit of a delay on the line, a bit like the telephone calls to America. There might be a bit of a delay, so we'll try and take it slow, okay? Can I just check you can hear me okay?
Yes, Alan. I can't remember what film that came out of. Yes, we can. But,
okay. All right. Just to begin with, in relation to the updated report, I see, just as a point of fact, at 2.2 of the background, that the application was deferred to allow time for the distance between in your space as well as Pilot's Row to be measured. Subject to correction, I don't believe in your space was in fact mentioned on the previous occasion. But in any event, to deal with in your space, first of all, in your space is not any of the, does not fall within any of the categories outlined within the guidance. It isn't a youth club. It isn't a place for vulnerable individuals either. It is, in fact, a theatre company which is involved, it seems, primarily in teaching circus acts. So it's put by us that it does not meet the definition contained within the guidelines of the type of place which it is felt that the amusements should not be within. It isn't a school, it isn't a youth centre, and it isn't a residential institution. The second point then, in relation to the Pilot's Row, there are 2 ways outlined in the maps in terms of how one can get to Pilot's Row from the from 15 William Street. The ordinary route that one would take along the main street is outside the 200-metre distance. It's 218.6 metres. As you can see, it is the area outlined in the maps in the blue, the light coloured blue route that appears in the maps. So it doesn't fall within the 200 metres. In relation to the other route, which is measured at 199.5 meters. The first point to be made is that if that is correct, it is 0.5 meters. In other words, about 18 inches or thereabouts, a foot and a half, with half a walking step within the 200 meters. But if we look at how that route is achieved on the ground, it would involve a very unnatural route, not the standard route, and a circuitous route, in fact, to try and get that way, where you have to turn left onto Chamberlain Street and then right down a gateway and along the side of the building and then around the front. Now, there are gates there which do not appear to be open all of the time. It certainly is not a route that would be deemed to be within easy walking distance, because that's the definition within the guidelines, easy walking distance. It is not an easy route to take. It isn't the natural route to take. The natural route to take is the other route, which is outside the 200 meters. In any event, even if one does look at that, it is very, very close to being the 200 meters. And as I'm going to come back to in a moment, that the council will know that the location criteria is a discretionary criteria. It isn't a mandatory one. It is a discretionary one, not a mandatory one. And if this is deemed to be within the 200 meters, and if further the council feels that that is a reason why it should be refused, in practice, it means that the several other amusement arcades that would also lie even closer to Pilot's Row, including the location of Winners at 38 William Street, which is in fact closer to Pilot Row, what it would mean is that they would not be able to ever transfer their amusement arcade licenses, because the transfer, as you know, involves a person making a new application. So this would not only affect this particular applicant, it would affect several other applicants within the city. And in particular, it would mean that those applicants are effectively prevented from ever selling or transferring any of their amusement arcades. That clearly cannot be the intention whenever the guidelines were thought up. The guidelines were thought up quite rightly to prevent new premises popping up. This isn't a new premises. As the committee knows, an amusement arcade has been in operation since 2005. And the reason this has been dealt with as a new application is simply because it is a transfer of ownership. That's it. It is in no other respects a new premises. It has been in existence for 16 years. Planning permission for it to operate as an amusement arcade has been in existence since the 10th of June 2002. So for 19 years, it has had planning permission to operate as this. So this is not a new amusement arcade. In relation to the 9 was the figure referred to in relation to the opening. In fact, it seems that it is less than 9, because if we look at the initial report that was prepared ahead of the last meeting, although in the narrative it does refer to 9 amusement arcades, whenever one looks at the map and the key attached to the map, there are only 7, of which this premises, the Wynn at 15 William Street, are one of them. So there aren't 9. It seems to me it must be the case that a couple of them have closed, but there aren't 9, there are 7, including us. And that is key to highlight. It includes this premises already, for the very good reason that it's always been an amusement arcade. Now, in relation to the legal requirements under the Betting, Gaming, Lotteries and Amusements Northern Ireland Order 1985, all of the legal requirements under the 1985 order have been met. It is right for the committee to take into account the contents of the updated report. No issues taken with that. As I say, there is a preliminary issue taken with the inclusion, if the committee is to consider in your space. We say that is wrong as a matter of law, that it does not meet the definition and it should not be taken into account at all. In relation to the Pilot's Row, we say that the natural way of getting there should be taken into account, which is outside the 200 metres, and that it would be a very circuitous and unnatural way with barriers in the way, in fact, in terms of gates and going along the side of a car park to try and get there within the red route. And even then, it is basically, it falls foul of the guidelines, and they are only guidelines, by about 0.5 metres on the council's own measurements. But it must be remembered that in terms of these criteria and grounds, the criteria and ground that relates to the location being within 200 metres of one of these premises is only a discretionary ground, not a mandatory ground for refusing an application. All of the mandatory grounds have been met. So even if the council were to feel that the 199.5 metre route should be taken into account, it does not follow that the council must or should even refuse the application. All it does at its height is give the council a discretion as to whether it should refuse the application. And we say that discretion should be exercised in favour of the grant of the application. In that regard, could I bring a few portions of the original report to the council's attention? Firstly, section 2.11 of the initial report, which indicates in that, and I quote, "It should be remembered, however, that the council may depart from the policy where it appears appropriate or necessary and the exceptional rationale for deviation is clearly presented." That, in essence, just puts into a more concise way what I've just said. At 3.3 of the report, the specific point that I've made about the existence of an amusement arcade there already is well made within the report. It states at 3.3 of the council's own report, given that an amusement arcade already exists at the premises to which the application relates, members may wish to use their discretion as to how rigidly to apply the policy criteria relating to the suitability of the location. In other words, the point I've made that an amusement arcade has already been here. This isn't somewhere new. It's not a new location. It's an existing location that only falls before the council as a new grant as a matter of form because of the fact that there's a transfer. That's it. If this is a renewal, wouldn't apply. If the existing owner was applying to renew it, we wouldn't be having this conversation. And I can't stress that enough, that this is already an existing arcade with planning permission for it. In relation then to the next section, of course, at 3.7, the point is well made that regardless of the council guidelines, as a matter of law, the legislation sets under Article 108, subparagraph 1, subparagraph CA, that there are mandatory conditions under the 1985 order, which are designed to ensure that under 18-year-olds do not gain access to it. That is whether or not somewhere is within 200 yards, 20 yards, or 200 miles, it doesn't matter. The law says there must be mandatory conditions to stop under 18s from accessing the premises. That ultimately is the safeguard here. So if there was any concerns, the law is there to safeguard against those concerns. At Appendix 3 then, if we could ask the committee to turn there just for some brief submissions in relation to Appendix 3. As the committee will see, the mandatory grounds for refusing an application do not apply. All of the conditions are satisfied in terms of the applicant being fit, etc. I'm not going to go through those. We did those on the last occasion, and the committee has the report, but all of the mandatory grounds in the council's policy permit have been met. That's in addition to all of the mandatory grounds under the 1985 order. So when we then turn to the discretionary grounds, all of the discretionary grounds, my submission, have been met, apart from the one potential query relating to this 199.5 meters versus 200 meters. But the point is well made within appendix number 3 that if one reads at the top of the page, suitability of location, that however, given, and this I'm reading from the council's report, given the fact that an amusement arcade has been operated at this location since 2005, some exceptional discretion may be appropriate when assessing the suitability of the location when determining this application. That's it, in black and white, that the point has been made again and highlighted that this is a case where, in my submission, there should be discretion exercised in favour of the grant. So, essentially, that would appear to be the only other issue that the committee requires to consider. Again, the recommendation of the updated report is not that this should cause the application to be refused. The recommendation of the report is simply that the members take account of the updated information contained within the updated report. No issues taken with that. It is perfectly appropriate for the members to take account of that information. As I say, I would urge the council to fairly quickly disregard anything to do within your space, because as a matter of law, it doesn't meet the definition of either a school, a youth club, or a residence for vulnerable individuals. And secondly, in relation to the Pilot's Row, we say the natural way of getting there falls outside it, and therefore the discretionary condition is met. The only circumstance in when the discretionary conditions are not met is if the committee feels that the red line means it is half a metre too close. And in that regard, I would say the committee should exercise its discretion because of the fact it's only half a metre, because of the fact that it has been in existence since 2005, because of the fact that there is planning permission, because of the fact that there are closer amusement arcades than this premises to Pilot's Row. There is also a Ladbrokes Bookmakers on Chamberlain Street itself, which is of course closer to the Pilot's Row than than the premises at Winds is. And point is, the council does not have to refuse it. The council can grant it, provided the council has taken into account all relevant information. The council is acting in accordance with the law in granting the application. If the council were to not grant the application, the applicant would have a right of appeal automatically to the county court. In the event of it going to the county court and the application is granted, there would of course be an application for costs being made against the council, and I would urge the council to not risk the constituents' ratepayers' money by refusing this application, which we say is properly made out as a matter of law. And in those circumstances, there is a significant risk that the council would subject the ratepayers to additional cost if the matter were to go on appeal and be granted, which we say it would be. And for all of those reasons, I would ask the council to take into account the information, but to grant the application for the amusement arcade license. Unless there's any specific queries I can assist the members of the committee with, they would be my submissions.
Thank you. Kieran, any?
No, I think Alan's made the main points. I think I would just be reinforcing them. And obviously it's a matter for the members. The only issue, obviously I would re-highlight is the aspect in relation to costs, that if this ends up in front of a court, obviously the issue has been addressed to the members now at this point, and in any application upon successful granting of the license, it would obviously be highlighted that the councillors were made aware, and it was something that was later not taken on board, but I have nothing additional bar that, so thank you.
Thank you, Kieran. Sorry, Brian. Sorry, just say to members, and given the nature, obviously, to the legal aspect of this, it's open to members now, as in terms of they want any clarifications either from the legal representatives or own officer, and then when that's concluded, we will go into confidential to consider and determine the application, and then come back out of confidential and make our decision known. So I'm just asking at this juncture, is there anybody who wants to speak to it, seek clarification? Councillor Ferguson, Rachel?
I think it's just clarification around in your space from our own team, because obviously whenever I've done my research on it, in your space is a circus school working with 120 people each week, but it's actually a charity that provide workshops for disadvantaged children and young people, and outreach programs, which I know on many occasions I've passed and seen a number of young ones using it as a hangout and a safe space. So just with the question over the legality of whether or not the definition that it can be used, because for me, I do see it as a safe haven for some of our most disadvantaged and vulnerable children in our district.
Thank you, Rachel. Councillor Tierney, Brian?
Chair, it's just a point, I suppose, of clarification at this point, and I don't want to even attempt to try and speak for Councillor Boyle, who raised my space at the last committee. In your space is in Magazine Street, Waterloo Street, up the side of the wall there, right? As I understood it, where Councillor Boyle was speaking about is the youth drop-in facility, which is just beside the City Man, the butcher, along there, in Waterloo Place. So I think, and the legal representative is absolutely right whenever he's talking about in your space. They are a circus production company, and I'm sure he's done his research, and I'm not arguing with that. But what I'm suggesting is that where this has been measured, this 62.6 meters, is actually the wrong place. It's not the same place I think Councillor Boyle was speaking about, and it's not the same place that I was under the impression that she was speaking about. So, and even when Councillor Ferguson is speaking there now and saying that she has passed it and she has seen several young people hanging about it and stuff like that there, that her description of what she's saying is the place that I'm talking about, that I think Councillor Boyle was talking about, which is I don't think the address is Guildhall Square, but it's just along that road. Oh, there, the Northland Counties building. just there outside the Guildhall. I think we've on the pack we've measured the wrong place, and what the gentleman's saying around in your space is correct. I'm not arguing that, but I think the information that has been provided and the distance to the place, I think the officers somewhere along the line got their wires crossed and we've got the wrong place here. That's just my opinion.
Sorry, Councillor Tierney, I think if you look at actually the map that's been attached to which number 3 in your space is on, and from what would have been the old Ulster Bank building is actually on that side, and it is a circus. It's not. Mr. Stewart's already made the points. I believe what there is another, and I'm trying to think of the name of, but they provide like educational services outside the Northern Counties building. That's a different. That's a different, which it's not. That's as I say, Rutledge, I think it's actually called. Someone put it in the chat there. That's correct.
Sorry, give me 2 seconds. Kieran, Councillor Tierney's asking you to, could you clarify?
In your spaces on number 3 on the map that's been attached helpfully by the council, and on the maps in your spaces on Magazine Street, as per when I look at their website, that's actually the address that's going by. The other aspect in terms of Councillor Tierney saying the Northern Counties, that's Rutledge. It's a different, and the Rutledge provide educational services to I think post GCSE, post 16-year-olds. It's not the same. And the other point to make is in your space was not raised on previous occasions. And if we're now raising Rutledge, my only point would be how many other areas, how many times does the council want to write the same report and add more and more places? Because ultimately a decision has to be made in this, and the council can't keep deferring it and deferring it.
Thanking you, Kieran. Folks, I have a list of speakers. Councillor Boyle, Michaela.
Yeah, thank you, Chair, and thanks for Councillor Tierney raising this. This was raised in confidential, I think, at the last meeting. But however, I'm aware in your space, yes, and you're very correct to point out, Mr. Stewart, that it is, but you know, an organisation that is involved with young children in terms of circus acts and that different type of events, you know, quite rightly pointed that out. Still a lot of young people attend that, but I'm not aware if that's actually in the same place anymore. However, it is my space that I was referring to in confidential, just for clarity, which is round by Guildhall, that direction. Yeah, I just wanted to make that clarity.
Duffy, Sandra.
Michaela sort of covered it there, Chair. But just, you know, in terms of introducing Rutledge and other places, if we look at our city centre, there is a proliferation of youth centres, places for young people to go. And it's my understanding as well that in your space, while it does circus skills, it also works with care leavers. So there is young people who are involved in it who have vulnerabilities and stuff. So I wouldn't rule it out on that basis either. So, you know, I think we can introduce any number of places. I mean, like there's Jefferson Court round the corner. There's any amount of places. But in your space, we should be taking that into consideration as well, because I do understand that they do work with caregivers as well. So it is a vulnerable group.
You, Councillor Duffy. Councillor McGinley, Emma.
No, it's grand. Councillor Duffy sort of covered it there. I was going to say that the place I think that Councillor Tierney was referring to was called Our Space, but it's not round there anymore. It's now an ice cream shop. So just for a point of clarity on that.
Thanking you, Emma. Councillor Tierney, Brian. You're not, sorry, you were just waving. Okay, back to yourselves, folks, in terms of the legal reps. Anything of that you want to pick up on?
But I mean, Derry City is not the largest city in the world, not even as big as Belfast, which in fact is the policy which came up with the 200 metres. I think what's probably happened, for understandable reasons, is that Derry City and Strabane City Council have lifted the Belfast policy guidelines and put them into their own. The 200 metres came from the Belfast guidelines. It doesn't seem that any particular consideration was given to how applicable that would be when one looks at the makeup of Derry City. I'm aware that there are a number of if we widen the definition to include services, to include provided care leavers, it would be difficult to find anywhere within the city that isn't within 200 metres of somewhere like that, because there are understandably a lot of good places that provide a lot of assistance to assisting those who assist the vulnerable. But if we were to do that, then all of the existing amusement arcades, all of the existing bookmakers, none of them would ever get a license. None of them would ever be able to transfer their license. If we widened the net to include all of those places, then there wouldn't be any bookies in the town. There wouldn't be any amusement arcades in the town. Now, maybe that's what some people would be quite glad about that. But look, there has to be a place for everything within the city. And this particular spot has been a spot where there's been an amusement arcade for about 16 years now. So it's not as if we're talking about somewhere new. There are no new concerns about this, because it isn't new. And I know I keep going on about that, but although this is in form an application for a new grant, it is in substance an application for a renewal. The only thing that's different is the name of the applicant. That's it. It is in substance an application for a renewal, where we wouldn't be talking about all of this. And I think that is a point that cannot be underscored enough. And it's a point that was, I think, absolutely front and centre in relation to the initial report. And we need to make sure we don't get sidetracked from that and go down alleyways about issues we don't need to go down, because we're not looking at a fresh location here. We're looking at a location that has got planning permission, that's operated for 15, 16 years. And if it was the name of the original applicant, the original license holder for a renewal, none of these considerations would be even troubling the council. It's simply because, as a technicality, it is an application for a fresh grant because it is a transfer. That's the only reason we're looking at this. We can't lose sight of that. And that's the reason, I suspect, why time and time again throughout the initial report, the council is urged to remember that, is urged, and this isn't our report, this is the council's own report. The council is urged to give consideration to whether or not, some laxity, some common sense, some discretion could be applied. And that's what I say we need to do here. We need to take a common sense approach here and take a step back and say, look, this place has always been here. It's not new. We don't need to start looking at all of these considerations because it's always been there. And in fact, if you take any of these places, whether it's my space, in your space, Rockledge, Pilots Row, they've all been there at one time or another whenever this premises has been there. All of those places are also, some of them are quite a lot closer to other amusement arcades. So if we take a common sense view of it, it's a case that's crying out for the council to exercise some common sense and discretion. And I understand everybody's concerns, and I'm not trying to diminish those concerns, but I just think we need to look at the context of this. If this was a completely fresh spot, we'd be in a different ball game altogether. But we need to just exercise common sense, take a step back and say, all right, look, to all intents and purposes, this is a renewal application with just a different name. And if this place is within a certain distance of all these other places, it's always been there for a start. And secondly, all the other places in the city are also within a similar distance. And some of the other places, some of the other amusement arcades are in fact closer. So look, that's what I urge the council to do. To not lose sight of that, please.
Thanking you all. And just to say to members and to anybody else that's in, we'll be moving shortly to Candy Confidential to consider and determine. Councillor Ferguson, Rachel.
I'm just wondering, obviously, with the question around it being a renewal and the application, obviously, I'm wondering if there's been any new applications granted with the new guidelines from council, because I know a lot of these arcades have been going for a long time, and this seems to me one of the first instances where it's had to come for a new application against council's policies of the 200 metres and other guidelines. I just wanted to know if there was any other ones recently since the new policy was put in place that has come through the committee and been accepted.
And sorry, Councillor Ferguson, Rachel, who's that to? The council officer or the
Yes,
legal?
council officers, please.
No, the policy came into being in March 2019, and since then the only new application that has been considered was one. There was a provisional grant of a permit for Castle Place. It's the ban, if you recall. But that's the only one. The other amusement permits, they have been renewal applications.
Thanking you. Okay, Councillor Ferguson.
Yep, Chair, that's perfect. Thank you.
Thank you. Folks, I don't see any further speakers, so I'm going to ask people to give us a couple of minutes, give the AT a couple of minutes to ensure we're in confidential, and obviously as soon as we've made our deliberations and determination, we will invite people back in then. Thank you.